नमस्कार दोस्तों, आज हम बात करेंगे हल्द्वानी दंगे के उस मामले की जो अब सुप्रीम कोर्ट पहुंच चुका है। उत्तराखंड सरकार और उनके वकील गौरव भाटिया चाहते थे कि मुख्य आरोपी अब्दुल मलिक की जमानत रद्द हो और वह जेल के अंदर ही रहे, लेकिन देश की सबसे बड़ी अदालत ने न सिर्फ जमानत बरकरार रखी बल्कि सरकार को भी कड़ी नसीहत दे दी। आखिर कोर्ट रूम में सीनियर अधिवक्ता गौरव भाटिया और माननीय जजों के बीच क्या बहस हुई, चलिए आसान शब्दों में पूरी कहानी समझते हैं।
Lordship, this is a very serious.
Put your energy in convicting him.
Your Lordship, that is happening. That is, but
Let it happen, Mr.
no, Your Lordship, I bow down to the observation made, but there is a responsibility of the state. A police station is burned,
You
petrol bombs are thrown at.
done your responsibility. Let us
No,
do our responsibility.
Your Lordship may then bear with me for 2 minutes so that I am satisfied I have done my responsibility well. That's all. Your Lordship, what has happened here? There is a statutory provision. UAPA Act is invoked. Your ladyship is just. May I please? So, Your Lordship, my first argument would be, Your Lordship, the UAPA Act, Section 43D(5), Your Lordship.
How does UAPA get attracted?
Your Lordship, it gets attracted for the reason he is the main.
Anyone throwing a bomb is a UAPA offender.
No, Your Lordship, I think that's a matter of trial for the time being.
We are asking.
So I'm replying to that, Your Lordship.
Justify your addition of.
I will, Your Lordship.
If you don't have UAPA, you wouldn't be before us.
Your Lordship, I will answer that also. As it stands today, Your Lordship, the UAPA Act was invoked, charge sheet filed. He is the main.
How it was invoked?
Your Lordship,
Today in a case of assault, if you.
it's not a
invoke
case of
murder,
assault. Arson, petrol bomb thrown,
all
police station burnt. Your Lordship,
accepted.
yes.
Tell us how UAPA gets accepted.
Your Lordship, may have the.
If a mob goes and burns down a police station, will that per se attract?
It can, Your Lordship. If it affects the public order, Your Lordship, it is a threat to. If it is a threat to.
Between public order and national security.
No, Your Lordship, under the UAPA itself, may I read the provision, Your Lordship? Your Lordship may see, all that I'm saying is they never said that UAPA Act itself per se should be quashed. I am on bail. Charge sheet has been filed. Trial is going on. So when I am arguing.
We have serious doubt about addition of UAPA. That is why we are not inclined to entertain your SLP.
So Your Lordship may see the, if that is one of the arguments I'm advancing. Second, Your Lordship, I would also state, look at the reasoning of the trial court.
Forget about reasoning. Liberty does not depend upon the inartistry of a court.
No,
Liberty depends
Your
on
Lordship,
the
is the
prosecution case.
there are judgments of the court on the Honorable Supreme Court where it has been said cryptic orders.
Judgments require review. We feel those judgments require review.
Your Lordship, cryptic orders, non-reasoned orders.
Absolutely, cryptic order what? One order, bail granted. If we feel that.
So Your
order-
Lordship, as the law stands today, Your Lordship, if my understanding is wrong, then Your Lordship, this petition should fail. But as my understanding is, the law of the land today, as enunciated by the Honorable Supreme Court, is there can't be a cryptic, non-reasoned order. The trial court, and I will go through the pages, Your Lordships may have a few observations of the trial court, overlooked by the High Court. In one paragraph, they say there is a plea of alibi, which has been dealt with by the trial court, Your Lordship. And if bail is granted in such a cursory manner without any reasoning, it will have deep ramifications.
Read para 6 will be High Court.
Yes. On the other, para 6 of the impugned judgment. Yes, Your Honor. Para 3. Para 6, on the other hand, Mr. J.S. Work, Deputy Advocate General appearing for the respondent, has opposed the appeal and submitted that the present appellant and his son, Abdul Moed, were the main conspirators of the incident. However, he has fairly conceded that as per the investigation, the appellant was not present at the spot on 8 Feb 2024, and the co-appellant Abdul Moed has been granted bail by the coordinate bench of this court. So, Your Lordship, two things. One, it's a case of conspiracy. Section 120B has been invoked. Physical presence at the spot doesn't matter because his role is very clearly defined. His house was used for a meeting where the conspiracy was hatched, and after that, the incident took place.
The point is that he is not at the spot when the riots take place or any violence takes place, right?
I'm sorry, Your Lordship.
He is not at the spot.
Absolutely, Your Lordship.
Violence takes place.
Yes.
Allegation is of conspiracy.
Yes, Your Lordship.
Whatever evidence he will lead, he will lead. For more than 2 years, he has been in custody.
Your Lordship.
For more than 2 years, he has been in custody.
Your Lordship, but for a serious offense where life imprisonment is also attracted. 2 years time, Your Lordship, we come before Your Lordships where life imprisonment is attracted. 2 years of jail, especially when a police station is burned, I would say cannot be a ground to grant bail. And Your Lordship may just have one page how the trial court deals with this plea of alibi, which becomes the main reason in the High Court impugned order. Your Lordship, there are statements of so many witnesses, I can show those, where they say he is the main conspirator. His house is used to hatch a conspiracy. He tells people to be there. His right-hand man is the one who's hurling petrol bombs at the police. And Your Lordship, after that, the bail is granted without a reasoned order. And therefore, what is the reasoning, Your Lordship? There are two parts to it, plea of alibi, and second is co-accused granted bail. His role is different, not discussed here. This person is the main accused. Just because a co-accused is granted bail in a mob violence, arson, Your Lordship, cannot be a ground that he has to be also granted bail, Your Lordship.
It's only a bail granted.
Your Lordship may see the danger he poses to the society. As Senior Additional Advocate General of the state, it is my responsibility to say, at least on merits, it needs to be heard to see whether there are cogent reasons or it is an order bereft of any reasoning. If there is no reasoning, it has to be remitted back, setting aside this order so that on merits it can be heard, Your Lordship. These are the orders which are shown in other matters also. And when they are shown, co-accused also are granted bail, Your Lordship.
In the light of this kind of facts, we don't really require a speaking order from the High Court. And the speaking order does not mean that you write an order of acquittal or conviction.
No, that about Your Lordship, in a bail matter, there would be no reasoning to the effect that there would be acquittal or not. But all that I'm saying is it needs better reasoning.
Reasoning is sufficient so long as it is sufficient to draw an inference of application of mind.
Yes.
The High Court should not grant or refuse mechanically, that's all.
Yes.
Where the High Court has applied its mind to the few factors, relevant factors, whether reasoning wrong, reasoning correct, as my brother has pointed out, it doesn't make any difference. And we are dealing with a matter of where bail has been granted. 2 years?
Yes.
2 years.
Your Lordship, but a bail granted in a matter which has serious ramifications for a criminal who's the chief conspirator. On the ground, the police also gets demoralized. Somebody burns the police station and he's granted bail, Your Lordship. It has a very demoralizing effect on the police also.
We accept to the extent, assuming that bail is granted for erroneous ground. Even then we should not interfere. Bail is bail. Why should we?
Lordship, what is the remedy available? The only remedy would be to come before the Honorable Supreme Court.
For a state, if you feel demoralization of the police is your concern, if within 2 years you should have convicted him.
Your Lordship,
You have abysmally failed in your primary
to that I would say, going down.
Try to cover up
Yes.
the failure of your primary duty by creating the color of seeking an SLP against cancellation.
So may I answer that? Your Lordship, after charge sheet is filed, the domain cognizance is taken, charges framed. We respect the court, Your Lordship. There is a judicial proceeding. Sometimes delay is not on our part. But to say the police has not ensured...
court to procure a conviction. It's the headache of the prosecutor to do it.
Absolutely.
And if the court
Subject to the orders of the court, Your Lordship.
if the court fails in its duty to ensure a quick trial, it's for the prosecutor to approach us for a direction.
And your lordship, exactly the same happened in another FIR concerning the same incident. The Honorable Supreme Court recorded satisfaction that 43 witnesses have been examined. That is FIR just next to this one, your lordship. So it's not that the state is not doing its bit. All that today I would finally make this submission to your lordship, subject to your lordship's discretion. This is a very serious case. All that I ask for is at least.
But the allegation may be serious. We are saying allegation may be serious. The man has been in custody for more than 2 years. Trial has not really taken any effective position.
Trial is taking place, your lordship.
How many witnesses?
One witness, your lordship, out of 105. Because I just checked.
You have examined one witness,
Yes.
and you expect us to interdict with liberty.
High Court has fortunately exercised its jurisdiction in granting bail. Why should we interfere?
And your lordship, my last argument,
With a better case.
your lordship, my last argument, if I may be given 30 seconds more, rightly or wrongly so, your lordship has expressed that UAPA should not have been invoked. My understanding of the law is slightly different. I would just say
We are not-
wrongly so if,
We are not
But-
expressing any opinion
Yes.
on that. It's for the trial court to decide in the course of trial or framing of charge.
but your lordship, my argument is just very important, your lordship. If UAPA is invoked, 43,
It's an arguable case. It's an arguable case for the defense with regard to applicability of UAP.
your lordship. So, your lordship, the prima facie satisfaction that needs to be recorded has not been recorded under the UAPA section 40.
So because we have a doubt as to UAP, we are not going into 45.
Your lordship,
43.
You can possibly question this order only after some time, provided that it's a case of misuse of control.
that would be cancellation of bail. I was on merits of the bail order. There are judgments of the Honorable.
Discourage these SLPs on merit of this.
Your lordship. I leave it at that, your lordship. I am very grateful for the indulgence, deeply obliged.